All right, ladies and gentlemen, if you'll come to order for a minute. Good afternoon, everybody. This is the subcommittee, the House Subcommittee of Rules on Lawsuit Reform, and we have one bill to begin our consideration of today, which is Senate Bill 68. It's about 3:48, which is not exactly the 3:30 time I had promised, but I understand the website had shifted to saying we were at 4, so I figured I'd try to average the two out and get started at roughly a time in the middle. I appreciate everybody's being here today. This is obviously a very important piece of legislation and one that merits due and deliberate consideration, so I wanted us to be able to get started on our review of it today. As I think I've indicated to many of you who have reached out to me, and as we indicated on the notice, this is hearing only. We're sort of just trying to stick our big toe in the pool today, and we appreciate so much the Pro Tem for being here to present the bill to us. My intention is just to hear from him on the bill, and as much time reasonably as he cares to spend on it and as we care to spend on it, and then to ask him questions. We will not take any testimony today, and of course we're not voting. We're just kind of getting started. So appreciate everybody's presence here today. Before we get going, I would like to call on Representative Al Williams to open us up with a word of prayer.
Let us pray. Almighty and everlasting, thou art eternal God, we thank you once again for a beautiful day. We thank you, Lord, that we've now gathered to take care of the business of the people. Keep our minds stayed on you, and let us be able to debate but not get mad. Bless this day, Lord, for it is in Jesus' name we pray. Amen.
Amen. Thank you, Representative Williams. If you'll bear with me a minute, ladies and gentlemen. One thing I do want to do, I think most of you know who our committee members or subcommittee members are, but I'll just go through and sort of introduce everybody quickly. Of course, we have Majority Leader Chuck F. Stration, Representative Stacey Evans, Judiciary Chairman Stan Gunner, the Appropriations Chairman Matt Hatchett. Matt, thank you for joining us here. The Speaker Pro Tem Jan Jones, the Minority Caucus Chair Lady Tanya Miller, Representative or Chairman Mark Newton, and Whip Sam Park, who is out of town this week, but I've texted with him and conferred with him, and so he'll be with us next week. And then Chairman Butch Parrish and Pastor Al Williams down there at the end, who opened the meeting for us. I think we have just a simple little bill here before us, I think, Mr. Pro Tem, don't we? It's interesting. I know we take up a lot of issues around here that sort of invoke a lot of passions. I'm not really used to amendments to the Civil Practice Act inciting that much emotion, but this is clearly a bill that a lot of people have a lot of interest in and a lot of concern about, and so we want to begin our review of it today, and we appreciate very much the Speaker Pro Tem for kind of rearranging his schedule for us to be here. So I'll turn it over to Senator Kennedy. And let me see if I can, where is it there? Right there.
Thank you, Mr. Chairman. Yes, sir.
1 second. Representative Evans, do you have something you want to say?
Thank you, Mr. Chairman. Yeah, just before we get started, I wanted to ask a couple of questions about the intent of our process going forward, appreciating that this is hearing only and that Senator Kennedy is here, Mr. Pro Tem is here to present the bill, and we're going to ask him questions today. But I understand the intent is that this will not be our last chance to ask him questions, and I wanted to ask you that to get clarity.
Well, I don't know that I had directly discussed that with him, but that was my intention. You would present today, and we might need to get you back on some other occasions as well to answer questions or talk about different parts of the bill as we move through it.
Yes, sir. I'll be available at your and the committee's disposal.
Thank you.
And then I also wanted to ask the intention of the chairman on public input and how much time will be provided for that and how much notice we can get out to the community, recognizing that while some of those folks are interests that have lobbyists out in the hallway and can jump, a lot of them are individuals that need to travel far and wide, and I want to make sure we give the public a chance to be heard on this.
Well, it's my intention to do just that. It's my intention to have a number of hearings, and maybe I will tell you and everyone here, my intention is to try to get some notices out tomorrow that will schedule meetings for next week and that would focus on specific issues from the bill, not necessarily just one issue per meeting, but I understand a number of people have different witnesses to talk to different components of the bill, and some of them are traveling, And so I thought it might be helpful if we could just give you that notice so you can get the folks you want to get here on the particular day instead of having to come all the time. So that's the intention. And I mean, we are going to have some time limitations just because space right now is a little difficult unless we try to meet out on the lawn.
On a day like today, that'd be nice.
I know, it wouldn't be bad on some days, but my intention would be to try to allow us to hear from everybody to the extent we have available time to do so.
And then one last question, if you'll indulge me, Mr. Chairman. I wanted to just ask and clarify that members of the committee that there will be ample time left for the committee to both deliberate and propose and consider amendments regardless of how long these times for testimony take.
Well, it would be my intention to allow a fair and reasonable amount of time to consider amendments and to just consider different issues that come up. Again, we do have some limitations of space and time that I'll have to impose at some point. So I can't make an open-ended promise to do everything you want as long as you want, but I will certainly try to afford a reasonable
Not unlimited, but fair. I appreciate it, Mr. Chairman.
Thank you. All right, Senator Kinney, again, thank you.
Thank you, Mr. Chairman. Good afternoon. Thank you to the members of the Special Rules Committee. I appreciate very much the opportunity to bring to you, as the chairman referenced, a bill that has garnered a lot of interest. I won't tell you it's just a cleanup bill. As we often say when we start, on some ways we do think it's a cleanup bill, but it's not a simple little bill. The concepts embodied in it are simple, and I'm going to break those down and hopefully explain them to you in a way that I hope will be persuasive. But I bring this Senate Bill 68 on behalf of our governor, Brian Kemp, in an effort to balance our civil justice system and stabilize costs for healthcare providers, job creators, and most importantly, Georgia consumers. This bill does come to you from the Senate with bipartisan support and passage from our chamber. Since 2016, the U.S. Chamber of Commerce estimates that the cost of litigation across the country has risen 7.1% year over year, far outpacing inflation. In fact, the Chamber further estimates that excessive litigation and nuclear verdicts cost Georgians roughly $5,035 per household per year. The impact of excessive litigation extends far beyond the courtroom. It reaches the small business owner who is faced with the difficult choice of laying off employees or shuttering his business altogether, all because the liability insurance premiums have doubled, or he or she has been told that being canceled, or because of the exit of insurance companies from this market render it such that he or she can't get adequate insurance. It also affects the pregnant mom who now has to drive 2 hours to see her OBGYN simply because her local hospital had no choice but to close its doors. This is the harsh reality when healthcare providers are forced to leave the state due to the threat of frivolous lawsuits. The truth is, it affects all of us, Republican, Democrat, young, old, male, female. A few weeks ago, Governor Kemp held a press conference introducing this bill and naming it his top priority for this legislative session. You witnessed, I think most of you were there, hundreds of people from all walks of life who came to the Capitol to tell us of the relief that they needed. Truckers, job creators, property owners, healthcare providers, big business, small business, folks that work for small businesses sent a clear message from the Capitol stairs. The status quo is simply not working for their business or Georgia families. Inflation has drained family bank accounts. Insurance premiums continue to rise. Folks at home continue to struggle to make ends meet, and businesses continue to be faced with a serious risk of closing their doors for good. For those who have doubts about this bill, my message to you is simple. Please don't buy into the message being put out there by some who are benefiting from the current civil justice system while the rest of our state is paying for it. Despite what you may have heard from the AJC's opinion page, this legislation is not about protecting corporate profits. It is not about caving to the demands of the insurance companies or denying Georgians the ability and right to be fairly compensated. Instead, it's about stabilizing costs and putting all Georgians, no matter their zip code, first. Well, if you don't believe me, let's look at a neighboring state. 2 years ago, the state of Florida passed similar legislation to what we are putting before you for consideration today. And what happened? Florida saw increased competition in the marketplace, lower consumer prices, and they are already seeing the positive impacts of the tort reform measures that they passed. This year, the state of Florida announced significant decreases in auto insurance rates. How about a few details? How about State Farm? They announced a 6% decrease in auto rates. Progressive announced an 8% decrease in auto rates. Geico announced a 10.5% decrease in auto rates. Florida has also recently announced the lowest average homeowners insurance premiums in the entire nation. I think everyone in this room knows that was not at all the picture that Florida faced and Floridians paid for just a few years ago before they had tort reform. Senate Bill 68 is about expanding protections for Georgians, stabilizing costs, bringing competition back to the market, and creating a good business environment. This legislation was not, however, as most good legislation, is not crafted overnight. Y'all remember Commissioner John King and the legislative leaders did their job by collecting data for 2 years and participating in roundtable discussions that our governor had around the state with businesses, healthcare systems, and everyday Georgians. Discussions around this bill did not, however, stop there. The governor said in his State of the State that there would be room for the legislative process to play out and the input from all sides on this important issue would be heard. And as I go through the provisions of the bill, you will see that is exactly what happened. The governor stood by his word. In fact, the bill is a result of dozens of hours of diligent work. And very briefly, the initial bill that was filed on the afternoon of the governor's press conference was even then further revised with input from the plaintiffs' bar, GTLA, and others, but mostly the plaintiffs' bar of this state, such that the substitute that was presented by me to the Senate Judiciary Subcommittee contained several revisions, all of which moved the various provisions of the bill in the direction of the concerns of the plaintiffs' bar. Now, this bill contains 8 reasonable solutions intended, as I said, to balance the civil justice system. I'm going to go through each of them, but if you don't mind, I'm going to give you just a brief primer. I know, and I can looking at the way this committee is populated, Mr. Chairman, we have several esteemed lawyers and members of the bar, but I think we have a few that maybe aren't. And if you'll bear with me, maybe no more than about a minute and a half or 2 minutes.
Is that a few members of the bar that aren't esteemed, or that are
no,
lawyers?
sir. All are esteemed, and some to be esteemed. How about that?
I don't know if I agree with you, but you're very kind.
All right, thank you. I want to go through each section and with a model that identifies the problem as it exists today under our current Civil Practice Act rules. I want to describe the proposed solution that's found in the bill and highlight those changes. But just a little bit of an overview. In any and every civil lawsuit that's filed, for the plaintiff to recover, he or she must prove 2 things. 1, that there is liability of the defendant to the plaintiff. And second, if there is liability, what is the amount of the damages incurred by the plaintiff that the defendant must pay? 2-step process. In virtually any kind of cause of action, in any court, if it's a civil action, the plaintiff must prove liability and then the amount of his or her damages. And there are 2 types of damages under that damages, the second part of the damages leg. There are general damages and there are special damages. Special damages are also known as economic damages. You may have heard that phraseology. And those are named that because they are calculable to a particular amount. The reimbursement necessary for a medical bill is of a particular amount. That is a special damage. It is specially calculated. General damages are non-economic in nature, and when you hear that, think in the context of what we're discussing as pain and suffering. That's something that the jury awards that's not derived from a particular number. Please understand that what we're talking about here is going to focus on special damages, especially when we get to Section 7 of the bill, and that's why I give that little bit of a primer. Section 1, this addresses something called anchoring. So what is the problem? Well, the problem is that when a plaintiff brings a lawsuit, some of the damages are already quantifiable, bills, lost income, things of that nature. But Georgia law also allows a plaintiff to recover, as it should, damages for pain and suffering, emotional distress, and other non-economic damages. It has been a staple of our law that the non-economic damages should be left to the enlightened conscience of an impartial juror. I think that phraseology has been in our jurisprudence for a couple of centuries. Recently, however, though, attorneys on both sides, plaintiffs and defendants, have aggressively attempted to anchor in the mind of jurors irrelevant and arbitrary amounts of damages or non-damages, or what the damages ought not to be, if you will, and that has contributed functionally to some excessively high verdicts. So what is the solution being proposed in Section 1? This simply allows counsel to argue the worth of the monetary value of the non-economic damages during closing arguments. Why then? Because at closing argument, all the evidence is in that the judge has said is appropriate, and the jury knows and has heard that evidence. Naturally, logically, fairly, the arguments that lawyers should make about the value of the case or what should be awarded to the plaintiff should be derived from the evidence that the jury has heard and not extraneous sort of concepts. And that's simply what Section 1 does. I want to be clear, though, that this provision does not place any limit on the jury's discretion to make that determination of what that amount ought to be. Rather, SB 68 protects the jury's impartial decision-making from irrelevant, untimely, and improper arguments from either counsel, so that the jury can do that which they are supposed to do, which is render a verdict as an impartial jury. That is Section 1. Section 2, which begins lines 52. This addresses, there are really three different specific areas of the Civil Practice Act that are addressed in Section 2. Number 1, motions to dismiss. Number 2, motions for a more definite statement. And number 3, the temporary stay of discovery. Number 1, the motion to dismiss. So what's the problem? Well, let's say, for example, give you just an example. Let's say somebody sues me, and they sue me as John F. Kennedy, the 35th President of the United States of America. Well, that's my name, but clearly that ain't me. They got the wrong man. I was not the 35th President of the United States. And so I want to file a motion to dismiss and say, court, I'm not the right guy. The plaintiff has the wrong party. Under our current law, although defendants, I can file a motion to dismiss in response to a baseless lawsuit, I still must pay my lawyer to file an answer and engage in the litigation aspect of this, in addition to the motion to dismiss. And in order to comply, the defendant will also have to respond, I would have to respond to discovery requests that even before really the court gets to the guts of the case, so to speak. So what is the solution? This section of the bill would simply allow the defendant to file a motion to dismiss in lieu of filing an answer. This section, as proposed, encourages the judge to rule on the motion to dismiss before discovery responses are due. It's fair, it's efficient for everybody involved. It's also an appropriate usage of the defendant's and the court's time and resources to require an answer to be filed, to not have to file an answer for a case that ought to be dismissed. Further, this provision should deter frivolous lawsuits, and that's really the heart of the objective here, to deter frivolous lawsuits that often rack up unnecessary legal fees prior to the judge's decision on the motion to dismiss. The second of the 3 points under Section 2 deals with a motion for more definite statement. The problem here is, under our current law, if a defendant cannot formulate an accurate response to a lawsuit or particular allegation in a lawsuit brought by the plaintiff because the allegations are so vague and not definite enough that the defendant doesn't know exactly how to respond, they're still required to provide an answer. This could leave a defendant wondering exactly what they're being accused of, but yet having to respond to it formally in a pleading. So the solution, Senate Bill 68, simply would require the defendant to move for a more definite statement before having to answer or respond to something that they haven't been given the details of which and know how to respond. The third of the three under this section deals with a stay of discovery. The discovery process is after the complaint is filed and the answer or the initial motions are ruled upon, the parties engage in discovery, which can be asking each other written questions called interrogatories, or demanding requests for production of documents and taking depositions. All of that involves the discovery process. The problem is that a defendant is unnecessarily, under the current system, paying to have to engage in the discovery process even while he's waiting on the court to simply rule on the motion to dismiss. This provides for a stay of that time period while the court is ruling on that motion or making that determination. Again, it's just efficient, it's just fair, and it tries to get at the heart of the problem of frivolous lawsuits that become very, very expensive on defendants, even when they're not supposed to be in the lawsuit at all. Section 3 of the bill. This deals with a provision involving a voluntary dismissal. So, once again, what's the problem? Well, currently, only the plaintiffs have the option of dismissing their case without prejudice, meaning they can refile it, all the way up until and including the time after the jury is picked and after opening statements, but before the first witness is filed. This standard clearly gives the plaintiff the ability to refile or cherry pick the venue or a more favorable jurisdiction. Let me unpack this a little bit and let me tell you how this works. So if I'm a plaintiff and I sue one of you and you're a defendant, you go hire a lawyer. That lawyer consults with you, gathers information, files an answer on your behalf, then engages in the discovery process in which you may have to respond to interrogatories, requests for production of documents, requests for admissions. You may have to sit for a deposition. There may be multiple witnesses that sit for a deposition. You may have to then go out and hire expert witnesses that are needed in the case. And all the discovery that's being done by both sides, this culminates and you're headed now to a trial date, potentially. There are motions filed. All of that can be rather expensive. You get a trial date. You find out you're going to go to trial on that Monday. You show up. The jury shows up. The judge is there. The voir dire, the jury selection process, is engaged. 12 people are determined ought to be sitting in the jury box. They take their seats. The lawyers make their opening statements, both sides. Now, this may have taken 6 months or it may have taken 2 years or longer. Under our current rules, the plaintiff can, after opening statements, before he or she calls her first witness, just say, I'm going to dismiss the case. I'm going to go refile somewhere else within a few months. And the defendant can do absolutely nothing about it. By the way, I think I said a minute ago, the defendant doesn't have that option. They can't choose at some point along that continuum that I just described to dismiss the case or have it moved or seek some action like that. So, the solution that this provides in Senate Bill 68, it simply puts a reasonable time limit on the time within which the plaintiff can file their dismissal. So what is it? Well, it's 60 days after the answer has been filed. So the defendant has time. They get to see the answer. They have sued someone. They get to see the answer. They see the defenses raised. And they have that period of time to help determine if, in fact, perhaps they've named the wrong person or if they need some information. They get 60 days of discovery and then can make a decision whether or not to dismiss, or if they're going to go forward, everybody goes forward. The next section, Mr. Chairman, is Section 4. This deals with something called duplicative attorney's fees. This one's a bit of a this is one that's a bit of a head scratcher, but we need to fix this because it really is a problem. Under the current law, the general rule is everybody pays their own attorney's fees. But we have some exceptions under Georgia law that allow for fee shifting, where based on the conduct of the parties, sometimes pre-lawsuit, sometimes post-lawsuit, where fees can be pushed off on the other side. That is, the other side has to pay your attorney's fees or some portion of them. And so what we are finding is that some attorneys, plaintiffs' attorneys in personal injury cases, when they are asking for their attorney's fees to be paid for by the defendant, if they meet the metrics of the particular statute, are utilizing more than one statute and getting a full double recovery under two statutes of the attorney's fees. Well, it doesn't make any sense, but the problem is we don't have a statute that says, wait a minute, if you're awardable or you should be awarded attorney's fees, okay, but you just get them one time. You don't get the double dip. This simply clarifies the ambiguity that exists in the law now. Section 5 deals with the state of our law now involving the inadmissibility of the non-use of seat belts in Georgia. I think probably just from prior legislative efforts, I think most of us are familiar with this. But the core issue is, right now in Georgia law, if I'm a plaintiff and you hit me and it's your responsibility and it's determined, let's assume that liability is clear, but I was not wearing my seatbelt. I made the conscious decision to disregard a safety component of my car, that is the seatbelt. The jury never knows that I wasn't wearing my seatbelt because we've got this one law that says it's inadmissible. Now, this is what I get from folks back home and elsewhere, non-lawyers, is a real head scratcher because they go, well, wait a minute, doesn't Georgia law require us to wear our seatbelt? The answer is yes. But we've got this odd law from a few decades ago that's still on the books that says the non-use is inadmissible. And it just may be that the jury ought to know that perhaps my non-use, my choice to disregard a safety component of my car, being the seatbelt, contributed maybe significantly to the injuries that I sustained because I wasn't wearing my seatbelt. It's just fair for the jury to know that when they get to the end of the trial and have to make determinations such as who is at fault for the injuries that occurred. By the way, this doesn't tell the jury at all what they're supposed to do with the information. It just gives them the full picture. That's Section 5 of the bill. Section 6 deals with negligent security claims. I will tell you, a lot of people have referred to this provision of the bill or a provision of the bill dealing with premises liability. But I would tell you that this bill does not address all issues when we think of and what's talked about premises liability. It is only one particular section or cause of action that is brought in the premises liability sphere, and it deals with negligent security claims. This deals with claims of liability and responsibility for a property owner when criminal acts of third parties occur on their property. So what's the problem? I think we know what the problem is, so I'll be brief. Businesses of all size, but particularly small businesses, are being held liable for the criminal acts of third parties simply because the act occurred on their property. Businesses, of course, have a duty to take care of their customers and keep them safe. Under our current law, businesses, though, are saddled with an enormous responsibility and, in turn, liable for acts, quite frankly, outside of their control. Let me give you one quick example of something that occurred a very short distance from where we all sit in the Capitol. Let's consider a Georgia company that's just a stone's throw from here that recently closed Racetrack, which was Racetrack on Piedmont, literally a 5-minute walk from here. The store provided fuel, affordable food, essential products to a once underserved community, and they did so intentionally and specifically 24 hours a day, 7 days a week. The community needed it. Racetrack invested substantial time, capital, and resources to build an asset for patrons in downtown Atlanta. This was a new venture for them with regard to where they were building this particular store. Racetrack made the determination to invest heavily in the community, and the community was quite frankly excited for the presence for what it offered. In light of some of the incidents occurring near their storefront, in light of what had happened around the area near their storefront, Racetrack increased its security. They spent tens of thousands of dollars to deploy around-the-clock off-duty police officers. They installed a mobile alert tower. They installed state-of-the-art security cameras. They installed at multiple levels different kind and state-of-the-art lighting to do everything they could to make the premises as safe as possible. Despite these investments, though, the store had to close its doors to the public, citing concerns regarding employee safety. However, all of the efforts I just talked about to prevent crime from taking place weren't enough to prevent Racetrack from being left vulnerable and liable for the crimes that were occurring even off their property and down the street. And they were forced to make the decision to close that store, meaning the people that were previously being served by them no longer had that privilege or asset or access just down the road. Our current law, quite frankly, folks, makes it almost impossible for businesses to achieve an environment to mitigate the impact of a litigation cost. So the solution that's being provided in this section. At the heart of the issue with our current law is the issue of foreseeability. An argument that, quite frankly, business owners are simply not likely to win. It's one of those that lends itself so easily to Monday morning quarterbacking of, well, something could have always been done better. Something more could have been done. You should have done this. You should have done that. So the solution is this clarifies the amount of risk associated with any unforeseen acts of the third party by establishing reasonable standards that both the plaintiffs and the owners of the property can rely on, providing clear guidelines on how to ensure the safety of patrons. We don't have those guidelines in the law right now. We have an area that has developed so quickly that the statutes have not kept up with this. We have some case law, quite frankly, but does not give owners clear lines of demarcation so they know what they need to do to make sure that they are within the bounds of what the law requires, and if they are, that they shouldn't be subject to unnecessary litigation. Very quickly, the three basic sections of the bill involve the three different standards that the law recognizes. One, and the invitee standard of someone on their property, which you would expect, and the law still requires, as this bill does, the highest duty that's owed by a business is to an invitee. Then there's also addressed in the bill the licensee standard, which is a slightly lower standard. And then the bill also addresses what to do with regard to a trespasser. These provisions set the standards that the plaintiff must prove in order for an owner or occupier to be liable for negligent security. Finally, there's a provision near the bottom of that section that specifically addresses security contractors. So this provision of the bill also examines that liability or potential liability in regard to a negligent security claim when a security contractor assumes or undertakes a duty to invitees or licensees to keep all of the premises safe on behalf of the owner or occupier. Hiring security in these circumstances simply holds the security contractor to the same standards as the owner if in fact they are hired for that purpose. And logically, the contractor is held to that standard because that's fair if that's what they've been hired to do. Section 7. And I've only got one more, Mr. Chairman, after this one, so I'm only 2 sections to go. Section 7 deals with something that y'all have all heard about of phantom damages. And it deals with how special damages are presented to the jury. Remember at the top of my comments when I talked about in my opening statement that there were 2 types of damages. You have special damages that are capable of being calculated by math, and then you have general damages involving pain and suffering that are not calculable but are left to the enlightened conscience of an impartial jury. It is important to note that Senate Bill 68 deals only with special damages. So when you hear me speaking of what this bill seeks to do, this particular provision, it's only as to special damages, not pain and suffering. What what we're currently seeing with jury awards across the state is a problem opportunity. It's an opportunity problem that stems from the way medical care providers bill and get paid. The process of medical billing, as y'all probably know, I wasn't really that familiar with it until digging into this, is really governed by a lot of federal law. But in these cases, there is a rack rate and there is the retail price for the medical services that are being provided by the healthcare provider. And then there's a contract rate, which is the amount of the negotiated price that the medical insurance carrier pays to that medical care provider. Mr. Chairman, I've got a little exhibit I'd like to turn around, but if I may, we've got copies in case everyone can't see for the members of the committee, if that's all right with you. What they're handing out is a copy of this same thing here. So let's talk about two different kinds of plaintiffs. Let's call plaintiff number one, who does not have medical insurance, and we'll call him Mr. Uninsured. He's involved in a wreck. Let's assume again that the person that hit him or was involved, the tortfeasor, the person that's liable, is 100% at fault. He gets a bill for the medical services that were rendered to him for $100,000. That's the rack rate for the hospital. To make the example simple, assume it's one hospital bill that provided all the services to Mr. Uninsured. And he has to pay $100,000 to satisfy that bill. His claim to the jury should be and is for $100,000. So that at the end of the trial, with a $100,000 award, he is fully reimbursed and fully compensated for his loss. Now again, not pain and suffering, we're just talking about the special damages for which he should be reimbursed. Remember, he should be paid every dollar that he is out to be fully reimbursed, but not a dollar more. Well, let's talk about plaintiff number two that does have insurance, which we know is virtually basically between the type of insurance that's available, from Obamacare to other types of insurance to employer-generated insurance. Most everybody's insured, by far. So let's call plaintiff number two Mrs. Insured. She gets that same bill. Let's just say she was involved in the same wreck, had the same services provided, $100,000. She gets the same bill, but is only out $25,000, because the contracted amount in the example that you've got in front of you is $20,000 is what's due to the hospital. And let's assume she had $5,000 in co-pays and other out-of-pocket expenses. So the total amount due to her to fully reimburse her is $25,000. And her claim should be $25,000 to the jury to be fully compensated and fully reimbursed just on these special damages. But Mrs. Insured gets to claim $75,000 as part of the bill that she never incurred and will never have to pay. That's the green section that you see. Because the jury sees the $100,000 invoice, not a $25,000 invoice, and award her $100,000. So you may be wondering, well, who pays for that windfall, that extra $75,000 that she doesn't need to be reimbursed for? We all do. We all do. And that's part of the problem. It's not just us in this room, it's hardworking Georgians across the state. Under our current law, this unfair process results in excessive reimbursements for which two people benefit: Mrs. Insured and her lawyer. Let's take this same concept out of the courtroom for just a moment. Let's assume you're involved in just a fender bender where someone rear-ended you. You're not hurt. You got a dented bumper. You want to get the bumper replaced. And you go to the auto repair place and they say it's $2,500. But what if you behaved as if you operated within this model? And you went to the guy that was going to do the repairs and you said, hey, how about giving me an invoice for $10,000? Why? Don't ask any questions. Just give me a $10,000 invoice, although I know at the end of the day I'm only going to have to pay you $2,500 to put on a new bumper. I think that's what we otherwise would know is called insurance fraud. But it's the same model, it's the same process, it's the same inflated invoice that's not truly related to the damage that we see here. Now, it's not fraud in the bodily injury context because the law allows for this under our current rules, and admittedly because of this confusion created with the way hospitals bill, sending out a rack rate that they know they're not going to get paid that amount, but that's just the model that we're in. That's why we need to change the rules to take care of this. That's what this provision of the section 7 of the bill provides. And you will see that it simply says in subsection C that the plaintiff, if the plaintiff has any form of public or private health insurance, and I'm paraphrasing, evidence relevant to the determination of the reasonable value of the medically necessary care shall include both the charged amount, that's the rack rate we've talked about, as well as the amounts actually necessary to satisfy the bill. I will tell you that is a compromise position. That is something that was negotiated on our side. It wasn't initially how the bill was initially dropped, nor as it came out of a sub. But again, the continued conversations and negotiation with the plaintiff's bar produced this change, again, to accommodate their concerns. Finally, Section 8 of the bill addresses something called bifurcation. Bifurcation in this context simply meaning dividing the presentation of evidence at the trial into two phases. Y'all remember at the beginning of my comments I said to you that there are two things that a plaintiff must prove. One, liability by the defendant that's been sued in the courtroom, and number two, how much does he or she owe the plaintiff based on the damages that the plaintiff has incurred. The problem is the current process mixes those two, because what's supposed to happen logically, fairly, equitably is the jury should first consider the issue of, is this defendant liable to this plaintiff for what he or she is claiming? And if in my example they got the wrong guy or wrong lady, or this defendant wasn't negligent in a way that harmed this plaintiff, then that should be the end of it. This allows for either party, not just plaintiffs, the plaintiff or the defendant, to ask the judge to bifurcate the trial, meaning you would have two phases. The first phase to determine that which should be determined first of, is the defendant liable to the plaintiff? And then if the answer is yes, you move immediately to the issue of the presentation of evidence of damages, and the jury then decides how much should be awarded. Now, I've heard comments about this, well, wait a minute, this is going to delay things, this is going to drag things out, different judges, no. It's the same trial, same courthouse, same judge, same everything. It's just the jury is asked to make a determination as to issue one, and if the answer is yes, this defendant's liable to the plaintiff, the judge says, call your first witness, let's talk about the damages. The jury needs to hear that, and the jury then determines how much should be awarded. Mr. Chairman, those are the 8 sections of the bill. I will tell you, a final comment if I may. I've had lots of questions which are certainly understandable and fair, and I won't go into the details unless asked, and I'm happy to. But as I said, as the bills initially dropped and proposed by the governor's office, because he said in his State of the State that he was going to be open to negotiation, he did, and his office continued to do that. that produced a substitute that I presented at Senate Judiciary. And if you're wondering, that initially the bill had 9 sections. This one only has 8 because of the objections to one section. The governor's office, with my agreement, made the decision to entirely remove that section. That was at the request of the plaintiff's bar. And then there was an floor amendment offered at the time that it was presented last week, and that is what has come to you. So I appreciate your patience. I know that's tedious, Mr. Chairman. Thank you for giving me the time to get into that. I'm happy to answer any questions.
Well, thank you, Senator Kennedy. I thought that was very good, a good run through. I'm sure we're going to have a few questions. I'm going to utilize my privileges or prerogative as chairman to ask one or two of you, if I may. I'm just curious, what was the section that was removed from the bill altogether? What did it address?
I don't remember the section number, but it was a section that proposed for OCGA 13-611, which was, as initially passed by the legislature way back, Title 13 is contracts.
Is that the attorney's fees?
Yes, sir.
Statute?
It's for attorney's fees when the defendant has engaged in bad faith.
Put the plaintiff to unnecessary trouble and expense.
And then there's a third prong. Yes, sir,
That's
exactly.
similar, yeah.
Yeah,
I can't remember.
those 3 prongs. The initial thought was to take it back to the original intent of the legislature, which that attorney's fee shifting mechanism should be available, but only in issues of causes of action related to contract.
Okay. But that was removed.
Yes, sir. None of that is in what's before you now.
Okay. Just one or two other questions as to the bifurcation. So we're right now currently the structure of the bill, just sort of looking at the fact that section 8 is all underlined. That's a new section. I assume you cannot. I think, can you request by motion for the court to bifurcate certain phases of a trial?
Mr. Chairman, you can, but it's not terribly clear, and it's not often used
common,
because it's actually, if I'm not mistaken, it's 9/11/42 that is under a provision of the Civil Practice Act dealing with consolidation of claims, sort of the opposite of bifurcation. But there's a provision under subsection B that references that you can have separate trials on separate issues if asked for, but it's not specifically worded or very clearly worded so that the parties can avail themselves to that under the circumstances of what we're talking about here.
And forgive me because I don't do a lot of litigation. Is there not a statutory provision on consideration of punitive damages in a separate phase of a trial, or is that just sometimes done as a matter of practice?
No, you're exactly right. And in fact, if you've got punitive damages, that would either be a bifurcated proceeding or a trifurcated proceeding, where the first would determine liability, the second would determine damages, and the second phase would determine should punitive damages be awarded. If the jury says yes, they go to a third phase, and that would be the phase where the court and the jury would hear evidence of the wealth of the defendant, so they know how much to punish. And so that is, as you know, traditionally kept from the jury because it's how much the wealth of either party is irrelevant unless you get to a punitive damages phase, which is typically in the third of a trifurcated proceeding. You could collapse it and have it in the second of a bifurcated proceeding. But yes, sir, you're exactly right.
My understanding had been that if there was an issue of punitives, because it involved something that could itself distract the jury, that oftentimes liability and compensatory damages were tried in one phase and punitives in the second phase, or am I mistaken?
Mr. Chairman, I've actually tried it both. I've tried it both ways. We're in a bifurcated proceeding or trifurcated. Yes, sir. And I think it depends on what the parties request. It depends on the complications and nature and also, quite frankly, how the particular judge, believes that the evidence ought to progress in a way that's best and most fair to everybody as presented to the jury. And sometimes that needs to be trifurcated, and sometimes it can just be bifurcated.
And so I guess it can happen right now, but I'm assuming it's sort of discretion of the court.
Total discretion of the court. The parties don't have a right
And your
to it.
Section 9 would make that more of a, if not mandatory, would at least make it more of a prevailing norm if someone requested it in a timely manner.
Yes, sir.
Okay. On Section 5, which had to do with seatbelts, some of the language there, I just was wondering, is that intended to, if I can find it, excuse me a second. So it says that that particular evidence on the failure, I guess, of to wear a seatbelt may be considered as evidence admissible on the issues of so forth, and may be evidence used to diminish any recovery. So is it still leaving it up to an argument and to the judge's discretion, or is the intention here that it's always going to be admissible and can always be used in argument as a sort of a failure to mitigate kind of argument?
I think, Mr. Chairman, I think it's number one, to answer your question, it's always admissible. Number two, how it would be applied and how it would be relevant and the utility of the evidence would turn on the facts of the case and how the plaintiff presented their case. It may be that it might, in fact, be highly relevant to an argument of contributory negligence, or it may not be about contributory negligence at all. It may have something to do with assumption of the risk or some of these other principles. I think which they would turn on would depend upon the facts of the case.
Okay. So I guess the court would still have some discretion as to whether it would allow it or for what purposes it would allow it.
Well, no, sir. I think A, it comes in, but B, I think it would come in and could be considered in any civil action as evidence on any of those issues.
Okay.
And depending upon the arguments made by the different parties, for example, assumption of the risk may not be an aspect of the case, so it wouldn't. But issues of negligence may be.
Maybe, okay.
Yes, sir.
So it depends on the facts of the case.
Yes, sir.
And then finally, on the dismissal, voluntary dismissal, Section 3, is that one of the sections where there were some changes made across the hall to the original bill? Was it originally a later date or an earlier date, or is that still much stayed the same?
You're exactly right, Mr. Chairman. In fact, this was yet another example of where, from what was initially filed, was moved in the favor and direction of the plaintiff's bar. Initially, this language was aligned with the federal rules of civil procedure, in which plaintiffs have up until the time an answer is filed to dismiss and avail themselves of the voluntary dismissal and then the refiling. But quite frankly, I think the plaintiff's bar made some good arguments that, wait a minute, there are times when there's some preliminary information that would be needed, such as proper parties, jurisdictional issues, and things like that. And we need a little short window to do some discovery. And again, the governor's office agreed. I agreed with it. I thought it was a fair move to make. And so this move to give an extra 60 days for the plaintiff to do that discovery.
Thank you. And one final question for someone like me who doesn't do a lot of trial work. The Section 1, which was sort of the, I'm not sure how you...
Anchoring?
The anchoring
Yes, sir.
provision. Tell me, could you give me examples of what currently happens now that would be prohibited under this language in your view?
Sure. Right now, as you know, the lawyers get to interact with the jury in voir dire and start asking questions, and that's the time for jury selection. But oftentimes, the lawyers will tell, and judges will let the lawyers tell just a little snippet maybe about what the case is. Depending on how the judge wants to manage the courtroom and how he sees certain issues, some lawyers will start talking very early about, ladies and gentlemen, this may be a $2 billion case. Or depending on the evidence, I may ask for $10 million. Whatever it is, those things that are said that can begin as early as those initial interactions between the lawyer and the jury.
Like in jury selection?
Yes, sir. Can begin that early to start putting ideas in the juror's mind to anchor them to certain numbers when the jury has received and heard no evidence about what the damages are, or maybe what a number associated with it ought to be, or what the medical bills are. And then that can continue beyond, of course, jury selection. And so this just simply is a very common sense approach. Says, wait a minute, before the lawyers start talking about that and numbers and suggesting, wait till the end of the trial when the evidence is all in, and those arguments need to be rationally related to the evidence that's before the jury.
So there's I guess a timing limitation as well as a substantive limitation as well.
Well, but once you get to, well, yes, sir, I guess it has always been, I think, the presumed law that the arguments of those numbers should be rationally related to the evidence. Otherwise, a lawyer's up there asking for something for which there's no evidentiary support and could get called down for that in an objection. So I don't think it substantively changes that part. I think it just clarifies the law as it's practiced and implemented now. But to your point, it does, though, change and set forth a timing aspect of when the lawyers can start talking. And it's not just the plaintiff, it's the defendants too. The defendants can't start talking in jury selection about, now this case really doesn't involve any money. There's no value here. You ought not award anything. No, that's not allowed either.
Okay, all right. Well, thank you. Those were just a couple questions I have. Okay. All right, I'm going to try to call in the order in which your light came on. Representative Evans.
Thank you, Mr. Chairman, Mr. Pro Tem. I want to start in section 2, and I understand the concern about going forward with discovery while you've got a motion to dismiss pending, and I get that. But right now, the way you described it, it sounded like the defendant files the answer and then discovery starts. But in reality, if you file a motion to dismiss, you agree with me, right, that there's an automatic 90-day stay of discovery?
There is an automatic 90-day stay of discovery that is a maximum of 90 days. And the problem is it doesn't account for when the court doesn't rule within 90 days, such that after that initial 90-day time, now the defendant is subject to all this barrage of discovery while he or she is simply waiting on the judge to rule on a motion to dismiss that may be a simple one-page order going, you're right, you're not the right defendant, you shouldn't be in this lawsuit at all.
And I assume that 90 days was picked because that same section that members who aren't familiar, you can find it starting on lines 86. In that same section, or a little bit above that, but in that section starting at line 76 actually. But I assume that 90 days for the stay was picked because that same section also says the court shall decide the motion to dismiss within 90 days. You agree with me on that?
Yeah, absolutely.
But sometimes the court doesn't.
Sometimes the court doesn't, but I think what is so potentially valuable and useful to all the litigants, the plaintiffs and the defendants, is this model says, okay, we're going to not expose the defendant or defendants to what may be totally wasteful and unnecessary discovery while the motion to dismiss is pending. But to your point, at the end of the 90-day period, the judge is supposed to rule. And if the judge doesn't rule, then the plaintiff is going to be asking the court to open or remove the stay so he or she can move on with the discovery they need to do. And that's contemplated and that's baked into the concept here. The defendant is going to be going, Judge, we're at day 91, you haven't ruled on my motion to dismiss. So now everybody's asking the judge to rule and rule timely as contemplated. Right now, as you know, that's not part of the process. All you have is a 90-day stay, and if the judge decides to take 90 days, 120 days, or 12 months, there's no limitation on that, and all the while the defendant's being engaged in discovery that's maybe very expensive and wasteful from the standpoint if once he gets his order dismissing him from the case, he's now been engaged in 9 months of discovery and a lot of wasted money.
I appreciate that. I'm trying to set the scenario here. You've got a motion to dismiss is filed, you've got a 90-day stay of discovery. For whatever reason, the court hasn't ruled. We know that our state court judges, some of them are going on a shoestring, and they don't have a lot of staff attorneys like the federal courts do, which they typically get orders out in 60 days because they have more help, and if they don't, they're going to show up on a list, sort of the tattletale list. You've got outstanding motions. We don't have anything like that here in Georgia, so there's nothing forcing a court to rule. And what I want to ask you about is, you've got the scenario, you got the motion to dismiss filed, 90-day stay of discovery, 90 days is up, the court hasn't ruled. We're putting all the burden and all the negative effect of that late ruling on the plaintiff and none on anyone else, and we're not setting up any way to force the court to rule. Now, you could say, oh, well, the plaintiff can ask the judge, hey, where's the ruling? Okay, denied. No one wants to file those motions. No one wants to file a request to a judge saying, hey, rule on my motion. So my question is, did you consider a 6-month stay of discovery, similar to what would probably be what we have in federal court? Or even better, was there any consideration of a way to put some pressure on the courts to rule? But because right now, I get the concern about a defendant engaging in discovery before you know what a motion to dismiss, how it's going to come out. But we're asking the plaintiff, the potentially injured party, the allegedly injured party, to bear all of that, to bear the load of a backed-up court that's not following the statute with no remedy other than to ask, hey, judge, can you open up discovery? But, let's just be practical. If the judge isn't ruling on the motion to dismiss, how likely is it that the judge is going to rule on a motion to open discovery?
Two things. One, as you acknowledged in the bill, it requires the judge to rule on the motion to dismiss within 90 days.
But no teeth.
Second,
what are we doing to put teeth in that? That's my question.
If you'll look at subsection J3, you'll see that it says, if the court has not ruled on the motion to dismiss within 90 days, the court may, upon the motion of a party and for good cause shown, terminate or modify the stay. So that's the safety valve for the plaintiffs.
But then the court doesn't have to rule on that motion either.
Well, Mr. Representative, I can't fix all the world's problems, but what I will tell you is the dynamics that come to bear here are very different, far more beneficial to all the parties, because now the judge is going to be getting it with both barrels. He's going to be getting the defendant saying, will you please rule? He's going to be getting it from the plaintiff saying, will you please lift my stay? Somebody or both parties are going to be saying, judge, you're not in compliance with the rule that says you're supposed to rule within 90 days. And lastly, I think to the point that's embedded in your comment, quite frankly, if the tie goes to anybody, it goes to the plaintiff in this. Because to your point, if folks want to start jumping up and down and sending the judge ugly letters about, judge, you hadn't ruled on my motion to dismiss, to your point, you're right. You'll get an order, motion denied.
Well, but the defendant's not going to do that.
We just disagree. To your point,
let me move on. At some point, I'm going to get cut off, so let me move.
Okay,
we disagree
sure.
on this vehemently. But understanding you started us here today talking about we've got to cut down on the cost of litigation. And I understand you believe a lot of that cost is from frivolous litigation and payout of damages, but you would acknowledge with me, I believe, and tell me if you would agree with me, that part of the cost of litigation is also costs paid to lawyers to defend cases all along the way. True?
Sure. I mean, anytime lawyers are hired, certainly. I
costs
believe
money.
I think we both agree lawyers ought to get paid.
Yes, absolutely.
And so that's part of it. But is that a driver of what we're seeing, the problems right now? No, because
Mr. Chairman, if I might, and I don't mean to be rude, Mr. Pro Tem, but I want to ask a couple of sort of foundational questions, so that, because not all the committee members do litigation as much as we do, or do it at all, and so I just want to set up a couple of foundational things and then ask you my real question. But if you go off on every single one of them, then we're never going to get to the point. And so if you just bear with me, I know everybody's going to want to go home at some point.
I'll do my best,
Okay.
but please understand, if you set up a false premise, I need to point that out, please. That's all I'm saying.
Well, and the
Okay?
only premise I'm setting up is that it costs money. You have to pay lawyers all along the way when you're in court. If you get sued, you've got to pay the lawyers to work the case, not just the damages at the end.
I don't think there's any dispute that, yes, defendants typically hire lawyers and lawyers get paid.
Right, so you're here to talk about how do we crack down on frivolous litigation. My question is, what do we do to crack down on frivolous defenses that get raised throughout the course of litigation? I think we would both agree no side is perfect when it comes to the arguments that they make in court.
You're right, no sides are perfect. Two answers. One, I've not had anyone suggest to me that frivolous behavior on behalf of defendants or defense counsel is driving up the cost that we're seeing that all of Georgians are paying. And if you think about it, it's rather kind of irrational to think that that's the case, because someone is paying that lawyer, whether it's the individual, the company, the insurance company, or someone responsible for providing that defense. Why would they be doing that? Now, does that mean it never happens? Of course not. The second part of my answer is that's why we have fee-shifting mechanisms such as in 91514 that I'm sure you're familiar with, that talks about the behavior of the parties and counsel after the case is filed. And so lawyers are free to go to the court and ask for attorney's fees if there's been I think the phraseology is a, quote, unnecessary expansion of the proceedings, close quote. That's one of the standards of 91514. So we have rules and mechanisms that address or would address that, but I would just say, to me, with all due respect, it's that's not something I've heard in walking along the way of trying to figure out how do we help hardworking Georgians, that insurance companies are wasting money telling their lawyers go waste money and file frivolous motions.
So you're not aware of the fact that there's plenty of folks that have as a defense strategy to bleed the plaintiff because time is money and they're not getting anything, their lawyers are not getting anything in the process. You've never heard of a defense strategy of delay. That's something completely foreign to you.
I'm not telling you it's completely foreign, but as a driver of the problem that we're seeing for hardworking Georgians with their insurance premiums and the other costs of frivolous litigation, no, I don't think it is.
I want to move to bifurcation.
Okay.
Representative, could I interrupt you 1 second? Let me just hit one other question, and if I could come back to you. Thank you. Chairman Newton, do you have your light on?
Thank you, Mr. Chairman, and Mr. Pro Tem, thank you for this. I appreciate you putting in a lot of layman's terms for those of us who aren't in court regularly, and it's very helpful, and I think it's been very well explained. There are two areas that I do have some familiarity with, Section 5 and Section 7. One deals with the seat belts, as somebody who's been part of a team that takes care of people ejected from a vehicle. First time I heard that it was illegal or against Georgia code to tell the jury that part of being ejected from the vehicle, which made their damages much worse, was inadmissible. So I appreciate you correcting that and giving the jury just the simple truth. Doesn't mean they're the only ones responsible, but I certainly understand that and I appreciate that in Section 5. Section 7, though, in your diagram that you show, I am pretty familiar with some medical bills, in particular, I mean, family members, grandparents, and we all get those, what's called an EOB, an explanation of benefits. Anybody who's had medical care knows there's a list price up there similar to what you show. There's usually, if you have insurance, there's a contractual discount that can be 75, 85%. Then there's an amount you owe, and that's where you start with your 20% of this amount you have to pay or deductibles and all, and the rest of that just goes away as part of the insurance process. So is what this bill trying to do is to, similar to we're getting the truth to the jury about seatbelt usage or non-usage, are we just trying to let them know that if this completely satisfies, gets a payment in full stamp on a bill for just $25,000 and not $100,000, we're letting them know both numbers after the amendment. Is that right? We're letting them know that the initial list price was $100, but $25,000 completely reimbursed all the health care. And then, by the way, if there's the $75,000 isn't like that would have been pain and suffering. That's general damages, if I understand right, not special that we're talking about. So we're just trying to let them know exactly what I explained to my grandparents when they want to understand a medical bill, which is here's the list price, but don't worry about that. Here's the real maximum allowable. Here's how much you owe, and here's how much your insurance pays. It's just giving them the truth. Isn't that correct?
That's exactly correct, Mr. Representative. I think you explained it better than I did, quite frankly.
I occasionally do medical bills, so I appreciate those two sections in particular, and I'm glad to get educated on all the other sections. But thank you.
Yes, sir. Thank you.
All right, Senator Kenny, I know I've kept you up that long time. Did you need to take a break? I think we do have some other questions for you. Are you good?
I'm fine, Mr. Chairman. Either way you want to go, but I'm fine without one.
You're very impressive to me, sir, being able to stand up there that long. All right, what's that? Oh, I'm sorry. Hold on, Charlie. Let me get Representative Williams. I think he had a question earlier.
Thank you, Mr. Chairman. I've been sitting here mesmerized by these brilliant legal minds, and as you was talking,
I sense some degree of sarcasm in that comment.
no,
Representative.
I'm very sincere, because as you were talking, I was thinking you close more times than a Baptist preacher when you're talking. But I was going to ask, from a layman's standpoint, because a lot of Georgians are not going to understand this debate at this level. They have two things. First, the small businessman says, my premiums are too high. The average citizen says, my premiums are too high. You mentioned Florida. I knew that there were going to be a lot of learned people, so I did a little homework before coming to this hearing last night and today. And you mentioned Florida. And my homework says that insurance is going up about a time and a half since Florida instituted tort. It also went on to say that the biggest problem in Florida has been the reinsurance market forcing premiums up sky high. Also, I learned that, of course, premiums went up, premiums have not come down, but it has done wonders for the insurance business, but it has shown no relief to the average policyholder in Florida. And the reason being not torts, but acts of God like Hurricane Andrew that cut off profitability for many, many years, and then a series of other hurricanes. So how are we to think that this is going to lower premiums, which it has not anyplace else? How are we, because we're here, I know my people want to see some relief, but we certainly want it to be realistic, and I have not been able to find where there's going to be relief as a result of tort reform as written here.
Great question, and I appreciate that question. And really, embedded in your question, in the heart of it, is one of timing. And to the comment that insurance rates have gone up in Florida, I've been asked the question many times, well, when will my premiums go down in Georgia? Tomorrow? Next week? Next month? And the answer is, I can't tell you the answer to that question. There are too many variables in that equation. I will tell you it's not going to happen overnight. I can tell you that unless we do something different, we will be guaranteeing Georgians' insurance premiums will continue to skyrocket. We do know that. Number two, I would tell you that what you are seeing in Florida, now while there may have been a lag, if you will, of the effect and the benefits of tort reform when it was passed, that premiums continue to go up, because just like here, the insurance market is not going to change overnight. It didn't in Florida, and it won't here. But it will change the dynamics so that insurers will want to come back to Georgia, just as they did in Florida. And specifically, the numbers that I gave you in my opening statement, or gave the committee in my opening statement, gives the details of, in fact, what's happening now. This year in Florida, they have the lowest homeowners insurance premiums in the country. That was not the case last year, the year before, certainly not 3 years ago. The numbers that were given, State Farm decreased their auto rates 6% this year. Progressive, 8% lower this year. Geico, 10.5% this year. So it takes a little while to take effect. And I expect the same, and there's no reason that we wouldn't expect and enjoy and reasonably anticipate those exact factors to come here in Georgia, because we have faced the same difficult dynamics of insurers leaving the state. So I think it is at its heart Mr. Representative, I think it is a timing issue. And as to the comment about acts of God, that's not what we're talking about. That's property and casualty type insurance. And you're right, we can't fix that. We can't anticipate that. That is a driver of those type policies. This, virtually every provision of these 8 provisions are geared at what to do about personal injury claims. And that is what the experts, that is what the insurance commissioner, that is what the product of the House Bill 1114 that was passed last year for the tort data collection bill, all of that went in to inform the governor's office of what ought to be in this bill based on what was learned from the insurance commissioner's report that would produce a more competitive environment and reduce insurance policy premiums as it relates to these type policies.
Misunderstood. For clarification, I did not indicate that we were debating property casualty insurance. I only put it in because that was a major reason many insurance companies left Florida. It was not tort. It was acts of God. That's the only relationship I did. Having written insurance for many, many years before moving on, I do understand the differences.
Yes, sir, I'm not suggesting you don't know the difference. I would just tell you I think we have different information. A lot of the information I've received is in fact that one of the reasons that insurance companies were leaving Florida is the same reason we're hearing they're leaving Georgia. It is the tort environment here for the policies that they're exposed for.
Oh, I'm sorry, any follow-up? Thank you. All right, Chairlady Miller.
Am I on? Hello.
Should be, there you go.
Thank you.
I think the mics are not exactly hot. You have to kind of
Get it, warm it up a little bit.
Yeah.
We'll see if we can get it warmed up. Thank you, Mr. Chairman. Thank you to the Speaker Pro Tem. I do have a couple questions for you. So you started your presentation talking about the fact that we need to stabilize costs. You rattled off some statistics, 7.1%, $5,035 per house per year. Where is this information coming from?
The first came from, since 2016, is the U.S. Chamber of Commerce, that the litigation costs have been risen 7.1% year over year,
Okay,
which
hold-
outpaces inflation.
Let me just make sure I'm getting it. So
Okay.
you said a 2016.
Since 2016,
Okay, but where are you getting this data from?
U.S. Chamber of Commerce,
And
data
is
from
this-
them.
And is this Georgia data or is this nationwide data?
No, this is nationwide. This is a U.S. Chamber of Commerce, not Georgia Chamber of Commerce.
Okay, and so that is there a date on that report or some place we can go and objectively look at these numbers that you're talking about?
I can certainly try to get that for you, but the data, the stats are since 2016. That is what the U.S. Chamber of Commerce reports has been the inflationary cost of 7.1% year over year.
And that's the inflationary cost of what now?
Of litigation.
Litigation specifically.
The cost, yes.
And it's the cost of personal injury litigation?
Yes.
Okay.
Yeah.
Now, and then the $5,035 per house per year, where'd you get that one from?
Again, the chamber.
Okay.
I believe that's the U.S. Chamber, but I'll be happy to get back to you and let you know if that's a Georgia Chamber derived data point or a U.S. Chamber. But I believe it's the U.S. Chamber.
Okay. And so when we say that there's $5,000 per house per year that's going up, in what way? How is that appearing in households?
It's in the insurance policies that you pay for your homeowner's insurance. It's the premium increase on your automobile insurance. It's the cost for excessive verdicts involving trucking companies that virtually everything we touch when you go to the grocery store, it got there on a truck. Most
Got it.
everything you buy got there via a truck. It is the additional cost that trucking companies are paying. It is, and I don't want to drone on and on, but those type things.
Okay, so it's basically the cost of insurance, the increased cost of insurance for people, yes?
It is that in part. It is in part the insurance, but it is the cost that businesses have to pay either through verdicts that they have to pay, increased insurance premiums, or additional costs because of the litigation environment.
Okay. And you talked about, I've heard the term frivolous lawsuits and excessive verdicts. Is it your position that frivolous lawsuits lead to excessive verdicts, or are those two different things?
Those are two different things as I speak of them. Can they both exist at the same time or the same case? Sure.
Can you tell me of a frivolous personal injury lawsuit that you would categorize as frivolous that led to an excessive or nuclear verdict?
Well, I would say one that most of us talk about in this vein is the CVS verdict.
Okay. And you
For a
thought,
$42 million verdict where there was an assignment of, I think, 95% of the responsibility on the property owner and 5% on the victim and 0%, as I recall, on the person who pulled the gun and shot the victim.
so a jury heard that case, correct, a verdict. And I guess the issue in that case, as it is in most premises cases, I just want to make sure we're talking about the same sort of proof that a plaintiff has to have. In order to bring a negligent security case, it's not just that you were the victim of a crime on someone's property. That is not sufficient in and of itself for a plaintiff to bring that kind of a lawsuit and be successful. Isn't that true?
You mean currently or under the proposed
Currently.
bill? Yes, not just being. No, there have to be allegations of negligence of some sort, yes.
And it's usually, there's a concept of foreseeability, right? That the property owner was in a superior position to understand the threat because of prior instances of crime on the property.
That is one of the aspects, yes.
And also, it has to sort of be a random attack. It can't be a targeted attack, right?
Well, again, we hope that's how it's interpreted.
No, that's
The
the law.
well,
If you,
but the-
you cannot, a targeted attack, if you're a person who is targeted, if I target my ex-husband as he's coming out of CVS because I'm angry about a custody dispute, I can't sue, they're not suing CVS because there's nothing CVS could have done to stop this targeted attack. That's typically how it works, correct?
Well, we hope that's the case, but that's not always the case because there are examples of where folks are having, simply because they own property or operate a business, are having to pay, or settlements are being effectuated because of arguments being made by a victim that criminal behavior should have been anticipated. And that's part of the core of this, is setting up some parameters. It's the foreseeability issue that you talked about. And it is so very easy to Monday morning quarterback or 3 years later talk about, well, there was something that put the property owner on some sort of notice and they should have known and should have done something differently. And it is that ambiguity, that lack of guardrail, lack of direction in the law as we have it now that we're trying to provide in this bill.
Well, I think that the law is pretty clear on what the standards are for bringing a premises liability case. It is not, property owners are not insurers of the property. They're not responsible for what happens on their property simply because it happens. There has to be some evidence that the property owner was aware of the danger, and then they did not do enough to protect their customers. Isn't that true?
No, I disagree. That's where
Okay.
you and I are not going to agree to say that there must be something that was done wrong because of the foreseeability issue and other aspects that are there.
Okay, so it's your position that if there is a property where no crime has been committed for miles, and they have off-duty security guards, all the lighting, all the bells and whistles of what would be an appropriate security measure, that if something happens on their property, that they are not protected by the law right now?
That's exactly right, and that's why Racetrack had to close their business.
Okay,
Because and I'll give you the example. What ultimately produced the decision that they had was because of some warring factions of people that were, I think, ultimately shooting at each other off of Racetrack's property.
Okay.
And they wind up in litigation for that. And so the problem is, your premise of your question is the law is clear on when there's liability and there's not. And I would just respectfully disagree that the law is not clear, and it stems from the opinions of the Georgia Supreme Court that have set the standard as the, quote, totality of the circumstances.
Okay.
That
now
does
you-
not set guardrails.
Yes, sir. Now, you mentioned racetrack and you mentioned CVS, and I do just want to make sure we're talking about the same cases. So the racetrack that we're talking about is the one that is near Georgia State University that was, well, did you know that that particular racetrack was called Club Racetrack?
Are you asking me that
Yes. Are you aware of that?
I don't know to what you're referring, so no, I don't know
Well, you
what Club
mentioned
Racetrack
racetrack.
is. Yes, I don't know what Club Racetrack is.
Club
though.
Racetrack, that if you Google Club Racetrack, that particular racetrack comes up. Have you ever done that?
Have I Googled Club Racetrack? No, because this is the first time I've ever heard the phraseology or name Club Racetrack.
Were you aware that it was a centralized hub on the property for multiple guns, shootings, gangs, streetcar racing, and that in fact, before the shooting that was the last one before they closed, there had been another shooting an hour before?
And are you aware of all the things that Racetrack did that was conceivable to try to bring security to that property? They did everything they could, and yet they still remain liable and exposed for a lawsuit. The end result of which is they have to close their business, and the people that used to get service by them no longer have that service.
Okay, but I asked you the question, so I'm asking you if you were aware of those facts.
I have heard some of the facts that to which you refer. As I understand the import of the comment or what's embedded in the question is, yes, by its very nature, criminal behavior is mobile and it is transient. And business owners can't stop that. But the nature and status of the law in Georgia right now is they're responsible for it.
They're responsible for it if it's foreseeable and they failed to do enough to prevent it. That's the law. Is that not the law right now?
That's the law, but there aren't guardrails and explanations and standards set forth on what is foreseeable and what is that standard. And the lack of those standards mean that it could mean one thing to this jury, something entirely different to that jury, mean one thing to this business owner, something entirely different to a different business owner. And so without the clarity and standards in the law, no one knows when they have done enough. And the jurors aren't given the law if they've given this totality of the circumstances,
Okay.
which is not fair.
Okay. So I want to ask you about CVS before my time is up because you brought it up. So CVS is a case that I've heard a lot about. And there was significant crime on the property at CVS as testified to by CVS employees at the trial, where they had been begging CVS to bring back the security guard. Is that true or not true?
I'm aware of 3 instances, I believe, over a 2.5-year period prior to this instance where there was something that had happened. The problem is, as I understand, and I may be confusing the cases and the facts, Madam Representative, but if I remember correctly, the incident that occurred on the CVS property was after hours. Non-customers that had gone to the CVS property to do a deal to sell an iPad to each other because they had met on Facebook or some sort of medium. And so there was nothing that CVS did that contributed to or caused the criminal behavior of someone coming on the property to do a deal that didn't involve CVS. But
Okay.
because of the lack of the clarity, we wind up with the vast majority of responsibility being assigned to simply the property owner.
Okay, I just want to make sure that we are speaking about facts. And so I'm just going to, you're saying facts, I'm going to ask you if these facts are your understanding or not. CVS had security guards at the store for a number of years, but in late 2010, they suddenly discontinued security. In 2011, an armed robber, held a gun to a CVS cashier and told her that if she didn't give him the money, she was going to get killed. After being robbed, the employee asked CVS to bring security guards back, but CVS refused. In 2012, a robber beat a female customer in the head in the parking lot and stole her purse. The customer reported the robbery to CVS. CVS did not bring back security. Again, in 2012, a month before the plaintiff in the Carmichael case was shot, a robber put a gun to the head of the store manager and forced her to open the registers. After that incident, a month before the Carmichael case, the manager asked CVS to bring security guards back. CVS refused. And so there is an actual testimony of this trial. And I guess my question to you is, if the jury, after hearing the facts of this case, determined that the conduct of CVS was the rationale for that jury, who are we to second guess that?
Because if the jury doesn't have the parameters set by the law as the legislature passes to say when there should be liability and not, then we are freewheeling and let every jury make a decision which produces highly inconsistent, unfair results across the spectrum, and not necessarily just unfair to the defendants. It may be unfair to plaintiffs because they're in a very conservative jurisdiction, and that jury decides we're not going to find any liability or we're not going to award damages. And so the point is to bring stability is to have a statute that sets the standard so that everybody knows, no matter where you are, what the venue is, what kind of business it is, what the plaintiff's injuries are, what the defendant's conduct is. We need those standards. That's what this addresses.
Mm-hmm. Well, I think that this is really an interesting issue, because you are speaking about a broad spectrum of cases, and I'm wondering if you have collected data, actual data, that the body can review to back up what you're saying.
Well, you're just asking me generically, do I have data?
I'm asking you
I
that
would refer you.
let me ask it specifically,
Sure.
so it's not generic. If you say that there are wildly different situations all across the state that shows our system is all out of whack, that should be documented somewhere so that we can review it and figure that out for ourselves. Does
Right.
it exist?
Yes, it does. It exists by the collective wisdom of what's going on in Georgia. And you ask Georgians and hardworking Georgians when they open their insurance premium what they're paying and what they're getting for it. You ask insurance companies why they are leaving the state and why they are leaving the market. You ask the insurance commissioner about his report that was produced pursuant to HB 1114. You can ask the governor's office about all the data that they took to inform them about what needed to be in a very fair and balanced approach to this problem. So yes, if with all due respect, if you were not at the press conference to see the hundreds and hundreds and hundreds of Georgians that came here begging for some relief, begging for something different because the status quo is not working, that is the amalgamation and the collective wisdom of what we're all living under right now, and that's why it's got to change.
What about all of the people who I have spoken to who appreciate that the 7th Amendment of the Georgia Constitution allows them to have their day in court and to have the representation of an attorney? And just because people did not stand behind the governor, would you not agree that there are other people across this state, in the hundreds and thousands, who go into these properties, particularly these slumlord properties? We know about this it's been well reported in the AJC, the hundreds of people who live under abysmal conditions because absentee, out-of-state landlords refuse to take basic steps to keep them safe. Have you met with any of those hundreds of people? Were they at the press conference?
You know why they weren't at the press conference?
I'm asking you, have you met with them,
Yeah,
and were
but
they at the press conference?
They were not at the press conference because nothing in this bill impairs their right to a jury trial. Nothing in this bill impairs their ability to get full and fair compensation.
Mm-hmm.
Nothing in this bill impairs the process by which they would have their special damages and their pain and suffering evaluated.
Mm-hmm.
So, no, they weren't here because that's not implicated, and I guess I'm not supposed to ask you questions, but if you'll tell me where the right to a jury trial is impaired in this bill, I'll work to change it.
I'd be happy to, but I think we'd be here all day.
And
I'll meet
Madam-
you afterwards if you
Madam
want.
Chair,
I have
I'd
to
like.
do that. Can I ask one more question,
Sure.
please?
Let's try to wrap it up.
One more area of questioning, and I'm sorry, this is let me just say this. This bill has multiple parts to it. It is a very complicated area. It is a specialized area. It is being oversimplified, and I am trying to get to the heart of some of the things, and it's going to take a little bit of time. I appreciate the indulgence of the chair and the Speaker Pro Tem. What in this bill will give relief to all of those people who stood behind the governor as it relates to their insurance premiums? What in this bill does that?
It's a collection of several things. Number one, if it relates to negligent security cases, it will provide parameters under which we all know if you own property or you're a business, the circumstances under which you will be found liable or should not be found liable. That will inform the insurance company so that they can effectively assess the risk. It goes to the issues of bifurcation, where that can produce a much more efficient way of trying the cases. It will go to the issue of the very unfair rule of the voluntary dismissal, where a defendant can be drug around for 2 years only to have the lawsuit dismissed at the last minute. Those are just some of the examples that run up the cost of anyone participating in the system. All of that collectively should work to lower the cost for litigants. Many of whom, when they are there, the freight is being paid for by an insurance company from the premiums that they pay to procure a policy.
Okay. So
Madam Chair Lady, could you?
He just said a whole lot, Mr. Chairman.
He did, and you're going to have another chance to take a few swings at him later on. We're coming up on our hard stop here, and Representative Evans's light is still blinking. I'd like to get back to her for a few questions.
Yes, Mr. Chairman.
Thank you very much. Representative Evans?
Thank you, Mr. Chairman. I wanted to go to bifurcation for a minute. It's new. This mandatory bifurcation, if a party asks for it, it's not something that's ever been mandatory in Georgia. It's not something that's in the federal rules. The federal rules say you can ask for it, but it's in the judge's discretion, which is what it's always been here. So this is new. I've talked to a number of judges that have expressed concern about the way this is going to lengthen trials, not to mention, concerns that I have that you're asking a victim who's injured to come in and have to testify at least twice if liability is found. So that's one premise of my question. The other is that this bill goes into effect upon signature of governor, except for the 2 sections, I believe, that deal with premises. And so you could insert a huge amount of new procedure into cases that are currently moving. So the combination of the new bifurcation issue that will lead to multiple trials with the same jury, I think you said, and the length that will add, plus throwing this new procedure in the middle of cases. Have you spent time, or was there any information that you gleaned from any of the testimony in the Senate about how practically and logistically this is going to shake out, and whether judges have they expressed any concern about that, or could you just talk about that a little bit?
Sure, I'm happy to. A good and fair question. Number one, this doesn't inject something that upsets the procedural process, because I think that the request for bifurcation can be made up until the entry at the time, I think, of the pretrial order, I think is the timing of when that can be done.
Well, not a request anymore. Now it's if a party wants it, a party gets it.
Well, but you request it first.
But it's not really a request if you can't say no to it, right?
Well, what you want to call it, a demand?
I think that's more accurate.
Well, but you know what? The plaintiff can do that too.
Sure.
The plaintiff can do it. The defendant can
but
do
it's
it.
New.
Anybody can do it.
I really just want to know if the judges are they okay with this? Have you talked to them at all?
I have, and I have had some tell me that they think it could be a very efficient mechanism to shorten the length of time for a trial. Because what your question doesn't consider is the example of a case in where the jury determines that there's not liability on this defendant, so the judge doesn't waste 2 days hearing about the injuries and the damages that the jury doesn't need to consider. It's not relevant because it's nothing they're going to pass on.
It's for those that are liability, though, the ones where the jury agrees, yes, Mr. Defendant, you messed up. Those are the plaintiffs that we're going to drag through 2 trials.
No, it's
right?
not. No, that is absolutely a
How is
misrepresentation.
that not? It couldn't be.
That is
it
not
could,
to. That
with
is
all due respect, it couldn't be not true. If a plaintiff wins on liability, defendant is liable. Those are the plaintiffs that are going to go to round 2, not the plaintiffs where there was no liability found. True?
Of course, but when you talk about 2 trials, that's very misleading because it puts in the minds of people that we're going to come back to the courthouse at some other day, some other time, with a different jury and a different judge. What this states in the bifurcation process, as I think you know, is as soon as the jury makes the determination of liability or not, if there is liability, the jury comes right back in from the jury room, they take their seats, and the trial proceeds. There's no delay. It's the same judge, same courtroom, same courthouse, same jury, same lawyers, same parties.
And the jury would deliberate twice as well, which sometimes takes
But
days, weeks.
But no, it's 2 different issues. Why do you think it would take longer if they're considering 2 issues 2 times versus having to consider 2 issues in one setting?
Well, because they've had to set through 2 different sets of. You and I disagree on that, but
Sure.
I really want to know if you talked to judges, because I didn't see any judges testify before. The ones I've talked to seem very concerned about this. The administration of jury service, people don't love to serve on juries. I wish they did. It's an amazing thing that we have in this country. But that is extra burden on our court system. True?
No, it's absolutely not an extra burden on the court system. This assumption that this is going to lengthen the time of trial is, I just don't think, factually based. And what is not accounted for in your comments and your analysis are those examples of where the jury determines that this defendant is not liable. So the jury goes home on Wednesday at lunch because they're done. They don't spend Wednesday afternoon, all day Thursday, and all day Friday hearing evidence about damages and injuries that are irrelevant because that's not for something for them to hear.
I like that. But the plaintiffs that are hurt are the ones that are coming back. I want to touch 2 areas as briefly as we can. I want to talk about anchoring, and you talked about in the voir dire, the attorneys talking about putting numbers that had no rational relationship to the case, in your opinion. But would you agree with me that lawyers use voir dire both sides to root out bias? Jurors who, no matter what, no matter how injured the plaintiff is, no matter how liable the defendant is for it, they are just not going to rule for this plaintiff for whatever reason. And the same on the other side. There are some people that they just don't like big business, and so defendants are going to, if they're a big business, are going to try to get them off the jury. So would you agree with me that we use voir dire to root out bias? That's a simple question, I think.
Yes, that is one of the purposes, yes.
And there
I agree
are
with that.
some jurors, individuals, who are just biased against large verdicts. And I don't use large and excessive as interchangeable, because sometimes the actual damages, I think you would agree with me, are big. And some people just don't want to give big verdicts, no matter how much they may be warranted. And big is in the eye of the beholder. So why are we going to cut off, and what's the rationale, what's the fairness of cutting off a plaintiff's attorney's ability to root out bias against awarding damages at all?
I don't think
Which
it
is what happens if you can't talk about dollar amounts in voir dire.
I don't think it does.
How so?
I think if you look at the language that you find beginning at line 33, and I'm paraphrasing, counsel shall not argue the worth or monetary value of non-economic damages, and the counsel shall not, in the hearing of the jury, elicit testimony regarding or make reference to any specific amount or range of amounts of non-economic damages. That's left to the enlightened conscience of the jury. I think in the trial practice that we engage in, you still can ask those general questions. You can ask those questions that we all do to, as you accurately say, to root out bias and determine what that bias is. What anchoring doesn't go to that.
Could you use dollar amounts in that? Under
This
bill, can you use dollar amounts in voir dire to root out bias?
I would have to have more facts to know what you're talking about.
I think we need to figure that out. And I'm asking my questions. This is a big bill. I mean, this could be 10 bills. And so I'm genuinely trying to find out. I mean, you and I have differences of opinions, but I highly respect you as a litigant, and I think vice versa. I am genuinely trying to find out what was considered, what might have been missed, what your rationale is. Just like when I'm hammering out a settlement agreement with opposing counsel, we're going back and forth and we're crossing out each other's language, but sometimes we had the same goal and we just disagreed on how we wrote it. I'm trying to find out that stuff. So I appreciate that we might need to come back to that. The last area I want to touch on briefly is seatbelts. Would you agree with me that we want?
And Representative Williams has one other question he wants to ask too, and I kind of need to get out of the room soon.
Well,
wrap that up quickly.
I was the only person who had to stop in the middle of my questioning, and I don't think Mr. Representative Williams will mind if I finish my question before he does his. Thank
And
you,
I don't
sir.
object you for the question either. I've been timing it, and I've tried to give you plenty of time to ask questions, and I respect you as well. But we do have some limitations on the amount of time we have in
And
here.
this is my last area, and with respect, I am an active courtroom litigator, active, as are a couple of members of this committee, but I think we would all agree, not most of us. So I am going to have more questions, because I have a lot more practical, personal experience with some of these issues that I think is important.
And I'm happy to entertain them. I just can't entertain them
Yeah.
in the next hour.
Well, I'm not trying to take an hour. I think I was very clear. I have one more area, seatbelts. Mr. Pro Tem, do you agree with me that we don't want any evidence related to seatbelts or anything else if it's not relevant to the issues before the jury?
I think I would generally agree with that. I think that's one of the gatekeeping mechanisms of the judge as he or she determines what's relevant or not based on the objections that counsel may be making. So with that proviso, yes, I would agree with you.
So I'm curious, and I thought that would be true. The way it's currently written, this may not have been on purpose, but currently in Section 5, if you look at lines 150 and 151, we are saying that seatbelt evidence may be admissible, and we list out admissible on issues of negligence, comparative negligence, causation, assumption of risk, apportionment of fault. Those may be things that I could get behind, but then we have, or for any other purpose. Why would we allow such a broad category of ways to get in seatbelt evidence that to me doesn't seem anchored to the facts of the case?
I appreciate the pun. Because I think just to make sure that because we're not perfect when it comes to drafting legislation, we're not perfect when it comes to writing the rules that you and I have to live under as we try cases, those identified 5 or 6 topics there may not be the only areas that would be considered under a fact pattern that neither one of us know right now before a judge that we don't know who's ruling over it might determine there might be some relevance. And so that there again, that's the judge's purpose. He or she is the gatekeeper of what is relevant. And so those specific items are identified so that it's clear that those are appropriate purposes for which to for the seatbelt evidence, but
Would you
also
be
just
okay
as
with-
just as a fail-safe to or other purposes. Again, the judge is going to be the gatekeeper.
But would you be okay? But he is, but we are too. So would you be okay with some language that similar to, and we'd work on this, but for any other purpose relevant to an issue in the case? Some kind of tying it back to, because I think arguably a judge could let it in for any reason or no reason.
I don't think so, because we're talking about evidence, and relevance is the hurdle that the judge analyzes every piece of evidence before it goes to the jury. If it's not relevant, it never goes to the jury. Again, that's the
That's your
gatekeeping.
intent, and maybe we just need to
No, it's not the
write
intent. That's the way judges do their job.
I just disagree that that's how this section is written. Thank you, Mr.
Thank you.
Pro Tem. Thank
Yes,
you,
ma'am.
Chairman.
Thank you.
Thank you, Representative Evans. Representative Williams.
Thank you, Mr. Chairman. And thank you, Senator, and thank my colleagues. The questions and the responses have been very informative for me, and it's really helped. I have no problem with any of them. But there's one question I have that cries out for an answer, and I've heard it asked several times. And this bill gets right down to, in many instances, businesses feel that they need relief. And as a businessman most of my life, of course, that's true in many instances, but how is it that I've heard the governor say, this is the third governor, and by the grace of God, we have been the #1 state to do business for 11 consecutive years. I've been on the Development Authority of Liberty County for 24 years and a year as chairman that I'm in now. I have never had a business turn us down because of insurance. And I'm wondering, how can we be the #1 company to do business and all these insurance companies are running from Georgia, but I've never heard that come up as a problem in what has been 11 fantastic years for business. It's an oxymoron. Explain to me how we can be number one to do business and the worst place in the world to have insurance.
Well, that's a great question, and it's not that it's the worst place in the world to have insurance. I think what you're alluding to is what others have mentioned, and I have too,
Yeah.
that we are 2 years running the number one state on the judicial hellhole list, close quote. That's not a name I came up with. It's not a list I came up with. It's not a publication that I wrote. So what that tells us is regardless of the metrics and yardsticks that are used to determine how bad our environment is, we know that we are the worst of the other 49 states. So to your point, and I think it's a great point, I will agree with you, I think we'll both agree, we will not and cannot remain the number one state in which to do business if we maintain the top of the judicial hellhole list. We won't be on the number one state to do business next year. Those two cannot exist very long. And I think, quite frankly, based on the press conference and the people that came, and it's not just businesses, it's folks, it's hardworking Georgians that are suffering under the insurance premiums that they're having to pay, and those that are struggling to get insurance, that have produced this environment that we're dealing with. You're absolutely right, Mr. Representative. We can't be on both lists.
I'm at 5:30 and I need to go ahead and close this out. I don't know if you have intentionally pressed your button.
I didn't know it was 5:30. I thought we had an hour. I'm sorry.
No, I think, well, it's actually about 5:40, but so we've gone about 2 hours. Again, we're gonna have time to ask the questions you like to ask. We just can't do them right this minute. It's kind of like the old saying, I want to go to heaven, I just don't want to go right now. So we'll have some more time. Senator Kennedy, we sure appreciate your time. Appreciate everybody's attendance here today. I will hopefully be getting some notices out tomorrow of some additional meetings next week. And Senator Kennedy, we intend to become really close personal friends with you over the next week or so.
Thank you, Mr. Chairman, and I appreciate the members of the committee and the questions that were asked. I really do. Thank you.
Thank you.
Yes.
Thank you very much, everybody.
Yes, sir.